Here we go, good to go. Good morning, ladies and gentlemen, those in the room and those online. My name is Godfrey Cromwell, and I know what you're all wondering. No, I'm not related to that one, and I'm not related to the other one either. Thank you. So I'm going to make 3 points before we kick off. First of all, the Economic Crime Bill has been referred to. It was a great victory, well, a great start to get that on the statute book. It's the first bit of UK legislation discussing slaps specifically, but it's not a victory. It's a beachhead. And from that beachhead, there are many, many more skirmishes and fights to come, as Peter very eloquently discussed earlier. I'm going to be asking Catherine to talk about the impact of it on her case, or what it would have been. Caroline is going to do unfinished business, that's her main role, and Roger is going to tell us why Scotland isn't going to become the destination of choice for slappers. I'm going to make 2 further points. One is the Solicitors Regulatory Authority has been touched on. They are investigating firms. I'm waiting to see what their report looks like before I ask you all to jump to your feet and applaud. Let's just see how that goes. And finally, and keeping an eye on the door in case I have to make a hasty exit, we all in this room believe in the right to disagree. And there's a danger that we mustn't be childish and consider every action against a journalist is a slap. Equally, there are people out there who've been referred to earlier who say slaps don't exist, it's all just a fiction. What I'm interested in is actually that middle ground. That's why we have judges. That's why they're called judges, because they have to judge, is this intimidation or is this someone trying to clear their reputation? And that's going to be tricky, and sometimes they'll get it wrong. But at least now we're getting stuff on the statute book that gives journalists somewhere to go if they have this sort of treatment from the kind of people we've heard about earlier. So I just want us to keep in mind that spectrum of opinion and the spectrum of cases, because not every case is a slap. So, coming now to your questions, please catch my eye, wave a hand or something if you wish to ask a question. We'll do questions at the end. And if you're online, we have the machine to pick up your questions. Please use the Q&A element to put those questions in, and I will endeavour to give everyone a go. One of my bugbears, one of the words we dread in the House of Lords is, "My lords, I'll be brief." If you ask a question, we give points for brevity. If you start to make a speech, I will simply cut you off. Okay? Unless you're... we all know you have fantastic CVs and work for marvellous organisations, but today isn't the day to tell me about them. Today is the day to ask your questions so that other people have a chance to ask questions. So please do bear that in mind. No speeches, please. Okay, so now we've got an excellent panel of speakers. We've got, going left to right, Susan Coughtrie, who's, I'm sure you all know, is Director of the Foreign Policy Centre and one of the co-founders of the Anti-SLAPP Coalition, who got a well-deserved round of applause earlier. She's sort of superwoman, really. Catherine Belton, former FT Moscow correspondent, perhaps the most famous recipient of slaps, I don't know. Putin's People, I'm sure you've all read. And I'm looking forward to hearing from her about how the landscape looks now and would have looked if the current legislation had been in place. Caroline is going to talk to us about unfinished business in the law, of which I think we could probably run a whole day, actually, but you know, it would be good to get the headlines. And as I've already trailed, Roger, who reminds us, if we need it, that Scotland has its own legal system and its own laws, and he's a free speech campaigner who's petitioning for slaps legislation in Scotland. We'll hear from him how it's gone. So without further ado, Susan, would you like to set the context for us?
Thanks very much, Godfrey. I think really I'll start with possibly the conclusion, which is that we've made a lot of progress over the last couple of years, particularly since we started the UK Anti-SLAPP Coalition in January 2021, but we are not there yet. So there is a lot of work still left to do. We've always, as a coalition, taken a sort of 3-pronged approach: legislation, regulation, and cultural change as key areas that all need to be progressed. You know, one on its own isn't going to be the silver bullet that solves this issue. And I'm pleased to say that I think we've seen progress in all of them. But, starting with legislation, it's as to use your term, a beachhead. It's not, we haven't, got onto the beach and sorted out all the problems yet. From my personal point of view, because my entry point into this issue was looking at economic crime, journalists who were uncovering economic crime around the world. Maria mentioned earlier our survey in 2020, which we spoke to 63 journalists in 41 countries investigating financial crime and corruption, and they were receiving, over 70% of them were receiving legal threats, which really pointed to us that this was an issue, but that the UK was the leading international source of those legal threats, and that was almost as high as those coming from EU countries and the US combined. So we definitely wanted to change the picture on that, and for the UK not to be this hub. And the fact that I think a lot of it has been linked with, and the cases that we talk about, we see that link. It's important that these measures have been included. But as Peter has very rightly said already earlier, and certainly the cases that we see now coming through the coalition are not just about economic crime. And as I think Catherine will touch on, even those cases that we know very well at this point would not necessarily actually be protected by the measures that have come in through the ECB2, to use your word, the Economic Crime and Corporate Transparency Act. So it's fantastic to see, I think particularly in a relatively short space of time, when putting together the conference booklet, which a number of you can see are already flicking through, we look back and realise that the first mention in Parliament of SLAPPs was in May, 27th of May 2021, on a Westminster Hall debate on world press freedom. Within 2.5 years, we've got anti-SLAPP measures in law. I think that speaks to the seriousness of the issue and how it's been recognised by many of us, but also by government. And of course, it also relates to a lot of what's been going on geopolitically and in the rest of the world. So I think, yes, on legislation, it's amazing that we now have something to work from. And implementation also of the measures now are going to be key. And as a coalition, we've analysed the sections of the Act, and we have some concerns about implementation, so we'll be continuing to monitor those. The second prong, regulation, well, we've also seen quite a lot of traction. It was exactly a year ago at the conference last year that the Solicitors Regulation Authority released its warning notice on SLAPPs. That was something that had been a key recommendation of the coalition, acknowledging this as an issue, and I've kind of always described the warning notice as both an educational tool, creating awareness of this issue, and also creating, hopefully, a framework by which to regulate against. We're still waiting, as many people in this room know, for the outcomes of the investigations that the SRA have launched, and I think we'll be kind of keenly anticipating those findings, and also the findings of the thematic review that the SRA is also currently conducting against its warning notice that was brought out last year. And I think the encouraging signs that I've heard from that is that it's looking not only at SLAPPs and law firms in a sort of narrow sense, but also looking at the wider ecosystem of how that connects to PR companies and reputation management, and potentially also private investigations. Also this year, we've seen others within the regulatory space speak out. The Legal Services Board, who are also speaking later today, are now looking at SLAPPs through the lens of their current programme on professional ethics and the rule of law, which I think is important for putting that wider context, because lawyers, I think, some of them have got quite upset with potentially being conflated with their clients. But for us, we've always said it's two parts. It's the tactics that you are deploying on behalf of your clients, and it's also making sure you know your clients. And there is, a process of due diligence that should happen, and knowing your client and being sure that you are not potentially in the, receiving the proceeds of crime, which would be illegal under POCA, the Proceeds of Crime Act. And then, I think last sort of strand, a little bit more nebulous, I'd say, is the cultural change. And I think the fact that the conference has attracted a wider audience every year, there's more people here in person, which is great to see. I think there's probably quite a lot of people online. And, you know, as Peter said I think in his keynote, 2 years ago, this was one of the first events in the UK on SLAPPs. And what's staggering now is to, as particularly as members of the coalitions, to discover there's events on SLAPPs that we've had nothing to do with and are happening entirely on their own, which is great, and that these conversations are happening. And there are going to be people who disagree about the solutions, and I think that's right. And I think a healthy debate about that is only going to get us to a much better and hopefully more robust and effective solutions that will carry in the long term. And, you know, the government task force that has been mentioned is also a really good sign of that kind of collaboration, discussion, looking for other ways to support you know, journalists. Reporters' Shield has been mentioned as an initiative. So I think we can be pleased at the steps in all the directions, but there's definitely a lot more to be done. So I'll leave it there for now.
Thank you very much. I'm going to take questions at the end, but just on the issue of more to be done, once I'd finished congratulating the government on bringing forward this amendment, which your organisation had quite a lot to do with producing for them, I did read into the record the concerns, the gaps and so forth, and we must remember that we can build out from that because it is on the record. Catherine, as I trailed earlier, you're someone who's been through the mill with this. I don't know if the beachhead would have made a difference to you or not, but I'd be interested to hear about that, and also interested to hear how you think it might work going forward. Over to you.
I mean, as Susan was saying, I think it's tremendous that this statute is on the books. I think it's huge progress. I'm remembering 2 years ago when I came to this first conference, and it was amazing to me to find there was a room full of people who were going through the same things that I was or had been, and were able to talk about it freely, because there's this huge stigma attached to being sued for libel. You're immediately kind of suspected as having done something terribly wrong, and you can't talk about it. I couldn't talk about my cases 2 years ago because we were awaiting the ruling on the preliminary hearing on meaning. But now, yes, the climate has changed. It's great to have this statute on the books, but to be honest, I think beyond the increasing general awareness of the tactics used in these type of cases, I'm not sure it would have been very easy to apply this economic crime statute to the claims against me. First of all, mostly the Roman Abramovich, Mikhail Friedman and Piotr Avin cases all mostly revolved around claims about their relationships with Putin or with the KGB, and that's rather a nebulous thing, and I'm sure they would have bent every which way they could to avoid being branded with this being associated with some kind of economic crime. There would have been long, lengthy and costly arguments in court to avoid this statute. I mean, first of all, you just have to look at the definition or how this current law defines what a SLAPP is. They've said the claimant has to be intending to cause the defendant harassment, distress, or costs. Now, this is quite hard to prove, and I think perhaps the Justice Ministry guidelines would have offered a clearer way on this, or perhaps they'll be made available to judges when adjudicating this. I mean, a lot of the elements that the Justice Ministry pointed out as indicating a SLAPP were present in the cases against me. There was the use of more than one jurisdiction, exaggerated claims. There was also the use of other statutes of law, such as not privacy, but data protection, in order to get around the restrictions of libel law. And so in the Abramovich case, which is the most famous one, I think, you know, he there were clear elements of all of this in the case. Like, he filed in 2 jurisdictions. He filed here, he filed in Australia, in order to boost the cases and double the costs and intimidate HarperCollins out of defending me. It would have cost more than £5 million to fight in 2 jurisdictions at once. And he also exaggerated his claims. I mean, the court at the meaning hearing actually threw out one of his most exaggerated claims, which was that the book said he had a corrupt relationship with Vladimir Putin, and the court had found instead that the book says that he's under Putin's control and he's forced to share his wealth with the Kremlin. But as to whether that could be adjudicated as being an economic crime, I mean, who knows? I mean, Abramovich's really central claim when he filed was that the book had said that he has a close and corrupt relationship with Putin and covertly acts on his instructions. And they said at a time when the climate is one of suspicion and deep mistrust towards Putin, this is going to cause serious harm to our client. Of course, we've all seen since then that Abramovich has more or less become an official envoy for Putin in the early back-channel peace negotiations with Ukraine in the first months of the war. And that relationship is now pretty much officially established. You've even had the head of the Ukrainian peace talks telling the Wall Street Journal, saying, well, we tell Abramovich, go and tell your boss, meaning Putin. So it's now, it's pretty much official. But again, I'm not sure any of this would have helped under the economic crime statute. And one of the main central claims that he had his main beef about was about the fact that we quoted 3 former associates as saying he'd acquired Chelsea Football Club in order to acquire, on Putin's instructions, in order to acquire soft power and influence in the UK. Again, this would have been very nebulous to fall under the economic crime statute. And I think there would be sort of a lot of wiggle room for him to try and avoid that, and which would end up still running up a lot of costs for my brilliant lawyer, Caroline Keane.
That you done?
Yes.
Thank you very much. I think you're right. One of the core difficulties is courts are very reluctant to look into the mind of somebody and try to impute what their motives were. They've always been very reluctant to do that. And, proving slaps is not going to be easy. It's going to be very interesting as precedent gets established, because, of course, this is brand new, how this plays out. But that brings us very neatly, I think, to Caroline, our legal expert, who's already had one plug this morning from the podium. Caroline, lots still to do, I believe.
Lots still to do. I do want to echo what everybody has said, that what we've got so far, it is quite fantastic in such a short period of time to have got something on the statute books. It is limited, but it is a wonderful, you called it a beachhead, it's a wonderful building block for where we go next. I mean, I'm not going to repeat what everybody else has said. This is obviously just a beginning. It's great that it's covering economic crime, but there are so many slaps that are not covered by that. Investigating NHS trusts, for example, building materials on the outside of houses, for example. There are loads and loads of examples that won't fall under here. But what is tremendous about it is that for the first time we've got an attempt to define a SLAPP claim. And we've also got, under statute, a direction to the Civil Procedure Rules Committee to come up with rules for dealing with this. Now, my heart actually sinks when I look at it, because while it's a tremendous opportunity, the difficulty in getting rules that will clearly help people to fight these cases and not simply end up in a vast amount of satellite litigation cannot be underestimated. I think anybody who is involved on our side of the fence in defending court cases should have the courage to try and make submissions to the committee when they're set up and give food for thought, because it is terribly easy. It's very easy at the moment to say, oh, there is a summary disposal regime in the existing acts, why don't we use it? But those of us who are in practice know that the minute that you apply for summary judgment, basically saying there's no no grounds for this case, you're going down a particular route that can cost you £250,000 just looking at that. And if you don't win, you effectively have to try everything short scale. And if you don't win, you've effectively lost that money and you're still going on to trial. What we need are things that simplify everything. One of the things that comes up again and again is the reason why SLAPPs are effective is because of the costs of litigation here in this country. And again, just as an aside point, we mustn't forget that while we're talking about anti-SLAPPs and getting rid of claims, claims are only the tip of the iceberg. The vast majority of SLAPP work is done at the point where somebody gets a letter and doesn't proceed to publish. It never leads to a claim. So what we mustn't look at is just the symptoms. We've got to get down to what's the disease. Part of the disease is the phenomenal cost of this litigation. It's partly because my learned friends at the bar, there are not that many of them, it's an incredibly specialist field, and they charge even more than solicitors. And I know that we charge enough as it is, but we do try and be on the side of the angels as far as we can. It is partly and primarily because the case law that's been passed in responding to the acts has made the practice of libel so complicated that I promise you that there are cases that I do, and I've done this work for 40 years, and I'm regarded as at the top of my game here. I don't understand some of the concepts I'm trying to deal with these days. I mean, I'll try not to be very legal about it, but I'll try and give you a tiny example, picking up on Peter referred to a case that we're dealing with at the moment. They published 2 articles. One of the articles refers not only to the original allegation that there were grounds to investigate this particular company, but it refers to a debate in Parliament at which it was named. Now, one of the great things that came in with the 2013 Act was that we had the ability for the judges to determine meaning at an early stage. That has been a phenomenal benefit to defence lawyers because it has saved a lot of legal costs. Believe it or not, you know, you're still talking about £100,000, but it's a lot of money saved. But we can't actually ask the court to determine the meaning of this second article because by virtue of the fact it refers to proceedings in Parliament and we want to rely on the privilege that goes with that, the judge, due to case law, can't actually make that ruling. Now, isn't that stupid? I mean, where's the common sense in this? So in my ideal world, I look at this, I go, this is amazing. I want to give all the support I can to the civil rules people, but we've got to track back from that. We've actually got to start looking, and this is a lawyer's thing, we've got to start looking at the case law that determines how it is handled. And what we've got here is the beginning, but it is so far from getting us away from the costs that are incurred in these cases that are the real evil, that we've got to look wider. So when we say where are we going, we're not just going here and saying, great, we've got now section 194 and let's get these rules sorted. We're not then saying we've actually got an amazing model law that'll cover all the other heads and let's hope we can get that through. But we've got to see the long game, which is to make fundamental root and branch changes to the case law that we have and the balance that's given in this country. We don't have free speech here, despite what everybody says. What we have is a law that protects reputation. And until people understand the difference between those and the importance of real free speech in the public interest, we're not going to get to the end game, which is free, fearless reporting of matters in the public interest. So I think we have a massive education piece.
Thank you very much indeed, Caroline. And give you due warning, I'm going to ask you what are the top next 3 things we should do when I come back to you. So get your shopping lists out, folks. Roger, Scotland, what's it all about?
Thank you very much and good morning, everybody. And as Lord Cromwell clearly understands from his introduction, in the UK there is no single legal jurisdiction when it comes to SLAPPs. Scotland in particular has its own separate legal system with its own defamation and other laws that are relevant to SLAPPs. To simply reform England and Wales law via Westminster runs the significant risk of merely encouraging SLAPP tourism. with Scotland becoming a preferred destination. And that's why I am very keen to ensure that doesn't happen, hence raising a petition with the Scottish Parliament that I'll say more about shortly. Is it realistic, you might ask yourself, to imagine that Scots law would become abused by some of the most disreputable people, both at home and in far-off lands? And I would say yes, there are a number of precedents. Let me mention just 2 cases that might be of interest to you. One is actually in the publication, which I fortunately read before coming up onto the platform. And that's the case in 2018, where it was a Scottish law firm who wrote to Oliver Bullough demanding the withdrawal of his book Moneyland. And that, to me, was a clear case of a SLAPP, and it showed the use of a Scottish jurisdiction to launch that. And the thing that I'm more interested in, however, as an example, although I'm very grateful to Oliver, who said 1 or 2 nice things about me in his recent book, was I'm more interested in coming at this from where my interest in corruption started. And that is with a thing called Scottish Limited Partnerships. I tried to run a campaign when I was an MP to get them either abolished or reformed. In 1907 it was, Asquith, through a budget, created these things called Scottish Limited Partnerships. They are extremely opaque business vehicles that had very limited use in Scotland for the next century. Along comes the great crash and all the political machinations of 2008, and oligarchs and some of the most disreputable people in the world begin to look around to find ways in which they can control and hide their ill-gotten gains. And they find Scottish Limited Partnerships. And within a very short space of time, thousands upon thousands of Scottish Limited Partnerships are registered, where we don't know who the owners are. They're not required to make any financial returns, and in a huge number of cases, they simply steal an address in Scotland from some unsuspecting person. And to me, if that is not an example of how the people who are pursuing these types of activities against the public interest are willing to shop around to find the best vehicle they can, to me it raised a red flag that when we're considering SLAPPs, it's not enough to consider only reforming the law via Westminster. So I wrote to the Scottish Government on the 29th of April 2022 about my concerns regarding SLAPPs, and I received an official reply from the government just a few days later, on May the 5th, which I thought was surprisingly quick, to say the least. And in it said, it was very nice, it said, "Dear Roger," which I thought was an interesting start. "Dear Roger, at this time the Scottish Government does not plan to undertake a review of SLAPPs." So it was saying it was not intending, but it was not saying the door is shut and we will not consider it. Now this led me to raising a petition, which is very easy to do in Scotland. One person can raise a petition and it needs to be considered by the relevant parliamentary committee. So I raised a petition and it passed some initial hurdles and was published in September 2022. Since then, it has twice been considered in a committee, along with written submissions from other parties. And on each occasion, it was unanimously supported by the cross-party petitions committee and has allowed it to make progress. It has now been granted a formal oral hearing, which I was hoping we would eventually get to at least that stage, where myself and a number of supporters, such as the Aberdeen University Anti-Research Hub, will be questioned on my petition by the committee in public session. that will be televised. And so too will they require a Scottish Government minister to attend and be scrutinised about their position. Now, this is real progress, I think, for a couple of reasons, but one I want to refer to in what Susan was saying, and that is, I hope this opens up the culture, opens up the way in which this is debated in Scotland, because it needs to be opened up. And I think having such a public forum and having this scrutinised can only be to our benefit. Of course, I also hope that as a result of this, the committee will decide to move the petition forward. They can do so in a number of ways, but I certainly hope that this will lead to eventually some type of action by the Scottish Government. But there's an awful lot still needs doing, as has already been recognised as the case in England and Wales, and an awful lot certainly needs doing in Scotland. My concern as an anti-corruption campaigner is in the longer run, and I think this refers to a point that your good self made, society needs to much better secure the principle of free speech in legislation. It's currently far too easy, in my humble opinion, to introduce laws that pay little regard to the importance of the public interest in free speech. And although investigative journalists are very much in the front line, they are not alone, as some other speakers have already indicated. Community campaigners and academics too are amongst those that can be affected by SLAPPs. My concern is that those opposed to reform make spurious arguments that there's little evidence that there is a need. They are often self-serving firms enjoying the fees paid by mega-rich individuals at the expense of justice and at the expense of public interest. Too often, as has already been said, SLAPPs prevent publication in the public interest without matters even reaching or getting near to the courts. As my petition argued, SLAPPs are abusive defamation and privacy cases, often initiated by mega-rich individuals with the intention to intimidate and harass individuals and publishers and prevent them from publishing information that is in the wide public interest. I'm really glad that progress is being made, and I certainly look forward to working with groups such as here today in the future. Just before going, I realise I've been talking about what I've been doing, but of course I don't operate in isolation, and it's very important to have support. And I see Nick in the audience and Susan in the platform and others who I simply want to publicly acknowledge and thank them for their support. Thank you.
Yeah, well done.
Thank you.
Well, Roger, thank you. I suspect many people listening will have learned quite a lot, whether they care to admit it or not, about the system in Scotland. And there may be a rush of people now putting petitions in if individuals can do it. We shall see. But thank you very much. I've got a number of questions that have come in, but Susan, I want to ask you first. This whole issue around culture. The legal process takes time and it is expensive. It has always been expensive and it will probably always be expensive to a degree. To what extent does naming and shaming, the sort of SRA and beyond that, or are the firms who practice this simply Teflon coated and don't care?
Well, you'd have to ask them, I think. But in terms of culture, for me, it's about having the conversation to begin with, because when I started researching SLAPPs, I mean, I was aware of SLAPPs happening in other countries, largely thanks to the work of many people who are here, who worked on cases in Europe, and of course Daphne Caruana Galizia's case, which drew many people's attention in Europe to this, but obviously there was work that was going on in the US beforehand. And I mentioned the survey that we did at the beginning. That wasn't actually talking about cases, that was just getting responses from people about all the kinds of risks and threats they were facing, but it was the fact that legal threats were A, so high, and B, that it was having such, they pinpointed legal threats as the type of threats that were stopping them from working, or had the potential to be the most difficult to overcome. And I thought, well, why aren't we talking about this more? And we followed it up with a report quite quickly, actually, which did look at some cases. And since then, we've just been trying to build up the cases, bring them into the public domain. I mean, of course, Catherine, Tom Burgess, Paul Radu, whose case had actually concluded and was one of the few cases I knew about at the time. And I had a very early conversation with Paul, asking, well, you know, there was no media coverage of your case, and it was in the public domain, and it was about to go to trial, settled on the eve of the trial. I said, was that a specific strategy that you had employed? You know, your lawyers suggesting you don't talk to media. You know. He said, no, we were just really busy fighting the case. And it just wasn't covered. There were a few media freedom organisations, I think, that had written a statement, but generally speaking, there had been no media coverage. And I just thought, well, I understand there's legal risk, but the fact is he is being sued. That's a fact. And that case is very interesting for a number of reasons, particularly because of what subsequently came out, and the fact that the person who sued him, his family members 2 years later had multiple millions taken from them using the original investigation and some of the information that had been sealed in that settlement, which happened just before the trial. But I realised that people needed to be able to talk more about the cases, and when I was meeting with people, there was a lot of nervousness, especially even just about letters, that they'd received letters marked private and confidential, not for publication. I can't talk to you about it at all. You know, this absolute kind of blanket. And I think also, you know, Catherine mentioned it, it's quite isolating, and usually what's happening is only the people who are sending the letters and the people who are receiving them are privy to them, particularly because they're communicated in this way. And therefore, you feel, I mean, I unfortunately have not received these, but from talking to a lot of people, you feel like you've done something wrong, it's shameful, you can't, I can see Peter nodding enthusiastically there, you can't talk about it. And I'd like to think one of the positives, and particularly hopefully through forums like this, is it has created a space for people to talk about it. And then once you start really taking greater shape of the problem, then you can more effectively start looking for solutions. And for the people that say there isn't enough evidence, it's taken this much to get what we do have. And as a coalition, we give advice and we talk to a lot of people now who are very concerned about this, but don't necessarily want to go public. They're going through a horrific legal experience. I think with journalists, there was perhaps more of a tendency to be public. That's something they were maybe more comfortable with. But there are, you know, individuals who are subject to this, who are going through a horrific thing. They might not want to then speak publicly. But I hope that we have created more of a space where there can be support and initiatives that can help. It's a very long-winded answer to your question, but...
Well, I think you have definitely created the space. It just needs enlarging, to go back to my beachhead again. I mean, I wonder if we'll see a day where people go and start gluing themselves to the rather nice offices of some law firms. Who knows? And I'm not advocating that, by the way, just to be clear.
I do think it's changed in the legal profession as well, just to say, because, you know, there are those who continue to say this isn't really a problem and what have you, but we have seen people move, and there has been positivity. I mean, the Law Society, Bar Council have welcomed, you know, the Economic Crime and Corporate Transaction Act and the measures in it. So, you know, there are positive voices, even if there is still some disagreement.
Yes, well, there's always going to be disagreement. That's the joy of debate. But
absolutely,
you know, that's the way it goes sometimes. Can I come to Caroline? You're on notice. That's what I'm going to come to you on. But Catherine, we've had a question come in about public interest defence. It's strong in. I mean, you may both want to comment on this, or indeed all of you. It's very strong in the US, of course. The question is, how are you finding it, particularly in the EU and the UK? The public interest defence, is it as effective, or is it less effective than in the US, would you say, if you have an opinion on that?
You know, I think we still have a very long way to go on that. The the way the UK law is structured means that it's tremendously costly to get to that stage. We would have defended some of our claims on the grounds of public interest, but it was going to cost an enormous amount to do so. As I mentioned before, it would have cost at least £2.5 million to defend the Abramovich claim on those grounds. Here in the UK, it would have taken more than a year to do so. You have to hand over all your electronic devices, all your notes. It's incredibly intrusive. In my case, it would have been notes for a book that I'd spent 7 years in writing, and more gathering more material while I was a reporter in Russia for the previous too many years, 14 years. So that's a lot of years to be handing over materials. So the costs could have just been gigantic. I think the 2.5 million was the minimum. And then we had Australia to deal with as well. And in Australia, when Abramovich's lawyers filed the case in Australia, I don't think there was even a public interest defence. So this was really raising the pressure on us. So yeah, it's obviously it was great to have the 2013 libel reform to allow that defence, but the way the law is structured at the moment, the onus is on the journalist. Still, the journalist is on trial. It would have taken us a very, very long time and huge costs indeed to get to the ruling, which no doubt we would have done, but it's just a tremendous risk for any publisher to take on, and most of them don't have deep pockets enough to take it.
Thank you very much. I can just about see beyond the lights, and so if anybody wishes to raise their hand and ask a question, I will come to them very shortly. I've got. Are you ready, Caroline, to give us your shopping list of the 3 top tips? Or
I'm not sure I'm going to give you 3, but I'm going to pick up on that because it also comes into one of my top ones. There is a profound difference between the law in America and the law here. In America, you have got the First Amendment and you've got the decision in Sullivan, which means that the claimant has to show that the material that's been published is published with malice, and that puts it into a totally different ballgame. It is very good that we have Section 4, the public interest defence here, but as Catherine has just touched on, in that case, it's the journalist on trial. It's not the claimant. It's not the subject of the investigation. And this coming down to my 3 things that I want to see changed. Sorry, that one is one of the ones that I primarily want to see changed. It should not be that you, when you have something that is clearly reporting on a matter of public interest where there should be a debate, it is not right, in my view, that it can come down to the journalist being the one subject to the entirety of the investigation on what did you know, what did you do, why didn't you ask me this additional question? Why did you use that particular phrase when you wrote this book 5 years ago? And effectively, in its purest sense, it's nothing to do with the subject matter, the wrongdoing that you're trying to expose. So yes, it's great that it's there, but it's fundamentally flawed. And until we get rid of the journalist being the subject, it's always going to be weak. What I'd like to see is that strengthened.
And that's a legislative change, is it?
Yes. Yeah, it's changing the wording of Section 4 because it talks about what the journalist reasonably believed at the time of publication. So you get into what did you know? You can't include anything you've learnt subsequently, and so on and so on. Why did you make that decision to publish? Why didn't you give me another chance to come back to you with my version, and another chance, and another chance, even though you've had 10 lawyers' letters telling you that we're going to sue you if you go on? We all know what we're talking about here. So it's great, but weak. What I'd also like to see, because I think it goes to the cost issue, is for, just as we now have the ability for a judge to rule on meaning, and he doesn't take any evidence in, he is meant to read the book or watch the film and take his own view as an ordinary member of the public on what it means and whether it's defamatory or not. It's actually quite quick. Most things are done in definitely less than a day, quite often half a day. And I don't see why the judiciary, properly directed, could not take a view on whether the subject matter of the book, film, etc., is in the public interest, as in this needs to be debated. I'm not taking a view on whether the journalist got it right or wrong. I'm going to say that this is something that is sufficiently important that it should be protected speech. And they should do that right at the beginning, as we do with meaning hearings. And if it's sufficiently protected, we stop it. Now, obviously, the subject matter must have the right to put their point of view forward, and there must be the ability to debate it. It shouldn't be a get out of jail free. But we need to see that there is a public interest in debate and protect that debate.
That's two things.
Yeah, I haven't come up with the third yet.
Yeah, all right, I'll give you another 5 minutes.
Yeah.
We had a question, you, sir.
Oh, hello. Oh.
Sorry, this is James with the mic, not Mike with the James. It's James with the mic, and he will find you if you put your hand up.
Okay, sorry.
This guy's next, by the way.
Okay, so this is Nick Williams from Index on Censorship, and there's another question for Caroline. You're talking about case law and the progress we've made of anti-SLAPP, but we're also seeing this at a time of privacy rulings and case law and privacy going the other way. So Bloomberg and BBC, the two really recent, very damaging, arguably damaging rulings in terms of the balance between freedom of expression and the right to privacy. How can we ensure that privacy is not this expanded space for SLAPP-like behaviour, and how can anti-SLAPP respond to privacy in the same way it does? Because obviously we know it's cause of action agnostic, but it's something we're going to have to respond to.
Mm-hmm.
Thank you.
Right, okay. Where we didn't used to have a privacy law in the UK, and it came in when the Human Rights Act came in. And then the privacy law that we have is judge-made. It's case law building on case law and precedent, as we all know. When it first came in, you kind of, as a practitioner, thought, oh, this is quite neat. You've got Article 8, you've got Article 10. They're both in their own little area, and never the twain shall meet. And what has happened over the years is that the Venn diagram between the two has now got a grey area. So into privacy law, has come reputation, and the claimants have been assiduous in saying that I have my privacy right includes my reputation, and moving the space further and further into libel. Again, it used to be, and nominally it still is the case, that you can publish and be damned, and that you can't get an injunction to restrain particularly fact-based free speech where you say you're going to defend on truth. It's completely the reverse with privacy, because the courts say our job is to hold the ring, and if this is private material, we shouldn't release it until we're satisfied at trial that there is a public interest in releasing that material. So privacy has become the preferred cause of action, because you can go in, you can get an injunction very early, you can plead that your children will be upset if this comes out. And by and large, the courts, because they've been taking a more neutral view of saying, okay, you know, if this is private, we've got to protect it until it comes out. We'll grant those injunctions and the stories don't come. So going in a very long way round, Nick, we need to carve out reputation from privacy and say this shouldn't be about reputation. It's got to be about free speech and debate. And the two cases you're talking about, I think it's appalling that inroads are being made so that now the right of somebody being arrested can plead that that's private. So that's what I would do. I'd carve the two out and again come back to we've got to protect free speech.
It's very interesting. Thank you. Sir.
Thank you. Yes, my name's John Heathershaw from the University of Exeter. Question for Caroline, and maybe it would be interesting to hear Catherine's view on this as well. It's a question about meaning hearings. I'm an academic who works on matters quite similar to what Catherine works on, and it's rather frustrating when you get pre-action letters telling you that your rather straightforward sentence should be revised to a 10-line one with multiple subordinate clauses. Yeah. So I'm quite interested in how far at the meaning hearing stage, not only is the judge, as you mentioned, thinking about it how a general member of the public would read it, but also respecting sort of professional practice around the kind of language being used. Because very often we've had the language that would be accepted within our academic field challenged by law firms in their letters. And that seems to me just to be perfectly unreasonable. So I'd just be interested to hear what is allowed in terms of meaning hearings as well. What
would normally happen in the meaning hearing is you've got the claimant's meaning, which is this very high meaning, And as the defendants, we'll sometimes say it's not defamatory at all, or we'll put forward what we say it should mean. It's absolutely for the judge to decide what they think the meaning is. They don't have to accept either. They can come up with their own meaning. They can take one or the other. But it is meant to be what the ordinary and reasonable reader would think it meant, but they will take into account the fact that if this is an academic publication focused at academics, you should look at this from the point of view of what would that reasonable reader think it would mean. But you know, this is the point. You get all these letters from all these lawyers setting out meanings that are just divorced from reality.
Thank you very much. Sir.
Hello everyone, my name's Charlie Holt. I'm one of the co-chairs of the UK Anti-SLAPP Coalition. I had one question I wanted to ask about the Economic Crimes Act. Lord Cromwell, at the beginning you rightly said that any type of subjective inquiry into the mind of the filer is likely to end in failure. And Caroline, I think, made a very good point about us needing to strive for simplicity. So I think in light of those 2 points, I'd be very interested to hear your thoughts on the Economic Crimes Act. The Economic Crimes Act amendment doesn't just depart from our model law in restricting the scope to economic crimes. It also departs from our model law in adding additional layers of complexity to the early dismissal mechanism. And that includes exactly the type of subjective inquiry you rightly flagged as being problematic. So my question is, how do we positively build on this without that mechanism or that legal framework then becoming firmly established in any future anti-SLAPP laws that are passed?
Just before I hand over to someone who actually knows about the law,
Oh, God.
There was a lot of discussion when we were pressing to get this amendment into the bill about, do we go for the whole model law, which would be the victim of when parliamentary time allows, which for anybody who doesn't know means sometime never, or do we pick our battles and get the beachhead? And that's what we went for. As I mentioned earlier, I then read into the record the various concerns, some of which you've mentioned, so that we can pick them up later. I don't think there is a silver bullet here. It's going to be a question of setting the precedents, a question of trying to get laws amended, but anybody who's had a private member's bill will know that trying to put in a whole new law is a very, very steep hill to climb. And this is why trying to amend the existing laws that come through, and the change of Secretary of State helped in that, I have to say, is the way to go. But each case, I think, is going to be complicated. It's going to be a matter of judgment, and you are going to have a degree of imputing motive. And I don't think you can really get away from that. So that kind of avoids answering your question. And before you work that out, I'm very quickly going to ask Caroline.
I thought I'd been very clever in bringing the sections of the Act up on my laptop so that if I got any clever questions I could look at it. And of course my computer has now died. But I did note that in the section that talks about intent, there is scope in there to say that it isn't drilling into what they intended, but what they appear to intend. And I think we have to focus on that. And I echo what has just been said in that it is vitally important that we pick the cases and we make sure that the cases that are the first cases are the ones that are most likely to appeal to a judge and set precedents in our favour.
Can I just underline that? Because in a different world, in the world of banks that have mistreated their customers, banks are extremely good at paying off cases they think they'll lose, and then going the whole way to court if they have some slightly eccentric person who's up against them, because that then starts building the precedent in their favour. So you're absolutely right. There's a lot of tactical legal work to do here. Thank you very much. We had a question. Where was it? You, sir. Just wait for the mic if you don't mind, unless you've got a particularly sonorous voice. And you're not allowed to plug your book either.
I've got a question for Susan, but could I just preface it by referring to what you said about private and confidential? I had one of those letters 2 or 3 weeks ago, private and confidential, not for publication. It's now to be found on the website of Private Eye. Dan Legal has referred it to the SRA, but that's by the by. Your research, you explained, sort of dealt with economic journalists, and you said that 70% of them had had problems with slaps, and that has, I think, in some quarters been represented as meaning that the economic ECCT bill Act will cover 70% of the cases. It's been mentioned by Catherine and Caroline and indeed yourself that it doesn't cover all the cases. What do you think the percentage is? If it's not 70%, is it 50% or what? Or would you hazard a guess?
I think, yeah, David's referring to the fact that there has been in some quarters perhaps misciting of our data, which has said that 70% of all slaps relate to economic crime, which is something we have never said and would never say, because how can we know what all slaps pertain to in order to then, you know, calculate a figure backwards from there? We produced a report, FPC produced a report last year together with Article 19 that I mentioned earlier, which referenced about 35 cases. By the very nature of the fact that our programme at FPC, which is called Unsafe for Scrutiny, was looking at this issue through this sort of nexus of media freedom and corruption. This is an area that our work had focused on, and therefore kind of the results are linked to that. However, we know, just in the same way we know that we'd seen the cases that are in report come to the fore through that research, that now we're seeing so many people come with so many different issues they're talking about. I mean, I hope that's reflected in many of the sessions that are happening over the next 2 days, and particularly the evening event tomorrow night, which is looking at slaps and silencing of victims of sexual assault. And so, you know, we will never know how many slaps are out there, because the fact is it works successfully on chilling at the earliest possible stage. And what we need to do, yes, we need to create a situation where there's a legal framework that is not so scary that anyone who immediately gets a letter thinks, oh my God. And then we also need to create a legislative framework where, you know, people know that it isn't just those receiving the letters who are going to receive this, and that they need to be mindful of the tactics that are used, the tones that are used, and that in fact there could be a regulator that looks over these if you're not sort of towing the ethical line. And then the last part is you know, being equipped to be able to deal with them, and there's a big educational piece. There's also other resources. I mean, there are quite now, thankfully, although never enough, resources for journalists. It's a lot harder to find resources for people who are on their own, or you know, some of the cases that come through the coalition now, it's individuals who are speaking out about matters on, you know, review forums or Facebook groups, and you know, this is all very new to them. So there definitely needs to be a lot more in that regard.
Thank you. I mean, is there a danger here? I'm conscious we've got about 2 minutes left, and I've got several more questions. But
we've got 15 minutes.
15 minutes late. Right, come on. Wake up, you at the back. Yes, I saw your hand. Thank you. Oh, that's great. In that case, is there a slight danger of what my father used to call jumping on your horse and riding off in all directions at once? Because, you know, there's whistleblowing, there's slaps, there's all of these things are sort of public interest area. Is there a danger that it becomes too disparate and diverse? Anybody want to have a bite? Roger.
Yeah, it's been very interesting listening to the discussion about public interest. And I was asking myself, who speaks in the public interest? And this is where I think it's so important to get a real cultural change. Because if you were to ask the average person in society, who speaks on behalf of the public interest, I would be very surprised if anybody is able to provide an answer to that. Whereas there's plenty of people who will act on behalf of reputation issues, individuals and the like. The other thing that I would like to say, at the risk of being ridiculed for this, because I've only just thought of it in the conversation that happened a few moments ago, thinking about reputation. It all seems very one-sided here. The person who is concerned about the reputation are, without restriction, able to exaggerate in public how good they are. But they require to be completely immune from any criticism. Now that strikes me as completely and utterly unbalanced, and that's why I'm concerned, as gratefully others are, to think we need to do ways of strengthening what we mean by public interest, and in my view we certainly need to strengthen this idea of a free speech in our society. There are plenty of people who say they believe in free speech, but only for themselves, not for the people who disagree with them. And therefore I do think there's a lot of work to be done in that.
Thank you very much.
I was just going to add one thing on that. I think what we've got to do is be very careful to keep separate in our minds supporting people who are being threatened with defamation proceedings who don't know where to turn, and anti-SLAPPs, because you said this at the outset. We can't say that every attempt to shut somebody down from saying something is a SLAPP. And I think we really need to concentrate on that level of quality of public debate rather than every individual saying, wait a minute, I've been threatened with defamation proceedings, that's a SLAPP. I think there's a lot of need for resources for people to know how to deal with something when somebody's trying to shut them down, but we shouldn't call all of those SLAPPs.
Thank you. We've got a gentleman here who's about to ask a question, but I think we need to include the online people. I have a rather intriguing question here. How do we get rid of the thick skin culture? Journalists should just put up with this, and shouldn't worry about having to say, oh, I've been slapped. They should just sort of put up with it. And I think the questioner was more suggesting, perhaps I haven't put it quite rightly, that journalists tend to put up with it when actually they should be claiming that they've been slapped and bringing it out into the public attention. Is that something that you would Catherine, perhaps, would you recognise?
I think yes. I mean, but I think that's definitely where we've been helped by this changing culture that Susan has described. And certainly we were in a very different place 2 years ago. I mean, when I first got my lawsuits and I got this email from Susan saying, oh, I've heard about this lawsuit. Do you need any support? And I was kind of shocked, and I didn't even want to respond to the email because I thought it was going to be something that Abramovich would use against me in discovery 2 years down the line and try to twist and say that I'd been lobbying. And I thought, no, I shouldn't speak to anyone. I just have to concentrate on fighting this in court. And that's what happened for a long while until the cases mounted up and it all got so egregious that the press started writing about it without me. So I think it's very important to have this change in culture and to be able to speak about things that you believe are SLAPPs. And I think it would be great to have this channel whereby journalists would feel secure in sharing with people what was going on in their cases. And I think Susan is already doing a lot in that direction. But if there were sort of here in the UK, the equivalent of the US AID fund, the Reporters' Shield, where journalists are able to kind of share the cases against them and in return also receive pro bono legal assistance. And I know Caroline is doing a lot on that front. And let me just digress a little bit, because I think what Caroline also said about the public interest defence and the ability to have that included in the meaning hearing could cut, excuse my French, a lot of the crap. Basically, we'd end up shortening a lot of these cases if the judge were able to make a ruling there and then in the meaning hearing that that's in the public interest. The claimant has had his ability to respond, his response, his denial or whatever is there in the text. That's it. The cases are over. And I think that would be a really important thing to somehow get into the culture of the meaning hearings as well.
Quite agree, and that's the thing we've all been striving for, and not surprisingly met a fair amount of resistance. Yes, it's in a way, to go back to the question, it's a sort of Me Too slaps almost, isn't it? Okay. I'm going to ask you about litigation financing in a moment. Just a chance to compare your thoughts on how you get it for if you're on the receiving end. I assume that is what the question is about that's coming online. But sir, you've been very patient at the back. Go ahead.
Thank you. Bryn Harris from the Free Speech Union. Following on from the question asked by Charlie Holt, it strikes me that the Economic Crimes Act not only has a subjective element, or at least an element concerning motive, but that it also draws quite a fine distinction between robust litigation in the best interests of one's client, and then on the other hand, vexatious litigation. And of course, the argument against that might be that puts a very slender test, and if you fall foul of it, then you lose sort of access to justice to vindicate an Article 10 right, and there's potentially some argument there. Is one way to resolve this to rather decisively go sort of full fat in favour of Article 10 and perhaps replace the damp squib that was Section 12 of the Human Rights Act, and to say that, and this is building on what was being said about the meanings hearing, to say that any speech that is prima facie in the public interest could lead to the striking out of the claim unless the claimant can rebut that prima facie evidence. That would be quite a radical resolution, but I mean, would the panel find that attractive at all?
Thank you. I mean, I'll come to the panel when they've composed themselves in a moment. I mean, I think we're back to the spectrum, to go to the early part of your question, where you've got cases that are clearly intimidatory and egregious, and cases where somebody is, perfectly entitled to defend their reputation. And if they want to spend millions doing it, well, that's what they think their reputation is worth. It's this middle ground, and it's not exclusive to this law, of course, where judges have to do their job. To the more specific Article 10 question.
Yeah, I mean, basically what you're suggesting is that we have the American system. Now, I'm a defence lawyer. I'm completely and unambiguously on the side of reporting and free speech. So, of course, I agree with you, but practically and pragmatically, we're never going to get that here. I mean, that would be such a change. So let's work towards that.
The lady in the white top there. Thank you.
I just wanted to bounce back on the points you made about the public interest. I'm the legal director of Protect, a whistleblowing charity. We're part of the Anti-SLAPP Coalition. Indeed, lots and lots of people speak out in the public interest every day. And the public interest can indeed take many forms, from a nurse raising patient safety concerns to a banker saying, hey, our new products are not compliant with the FCA's regulation. So I really think, actually, rather than undermining each other, SLAPPs, the fight against SLAPPs and the fight to make whistleblowing protections more effective sort of, strengthen each other. And that's why I'm here today.
Thank you very much. I don't think there's a question of undermining each other. I think that quite often people tunnel along in parallel, and it's a matter of linking those tunnels up. I mean, tomorrow there is an all-day event on whistleblowing, as it happens, for example, which I will also be attending. But I don't know if anybody wants to comment on that. I do worry about the sheer breadth we're trying to take on here, and you won't get a law that covers everything.
I mean, I would say one of the positives about the amendments, or the now sections of the Economic Crime and Corporate Transparency Act, is it doesn't define the defendant in the sense that it doesn't have to be a journalist who's raising the concerns about economic crime. It could be a whistleblower, it could be anybody who's speaking out in the public interest. It's the public interest part that is key. The concerns that have been raised by Charlie and others is the concern around the subjective nature, both of the, what did the claimant intend, but also, interestingly, in this section now, why or what was the sort of aim of the person who was speaking out about the economic crime. And these are the things that, Caroline was talking about that add up to the additional costs that we don't necessarily need to get into and is not in our model law. So, I mean, I'm getting towards the end here, but I mean, my suggestion, unsurprisingly, is that we move towards, closer to what is set out in the model law. And I think that would be something that could help at this stage. There are always issues in other parts of law, and I know there are many people who support the model law, but recognise there are also things we could do in, for example, defamation, privacy, GDPR, all individually. And I think costs are always going to be the biggest thing, and particularly for these sections to work, you have to go through these measures. But if you are worried that you're still not going to meet the test, you are still going to face those same cost issues. So unless we deal with costs for everybody in defamation to a certain degree, it is always going to be a concern, and there is always going to be a chilling effect.
I think it is always going to be a concern because, you know, the parties that are either end are going to pull that line one way and t'other, aren't they? And in case by case, I suspect you're going to start coming down with judgments, and that's where the precedent will build up as to what was acceptable in the previous cases. But at the moment, it's kind of virgin territory. But unsatisfactory though that is, you know, it's part of the human condition that the price of freedom is eternal vigilance. You know, you're constantly trying to make sure that the other party isn't pushing it too far this way, and they're trying to do the same to you. So if only life had simple answers, but sadly it doesn't. Sadly, I think we're very nearly out of time, but I don't know if you've got any more on there. One more question, who's going to be the lucky winner? Any takers, or are you all completely satisfied? Well, they're completely satisfied, or else there must be... Oh no, there's more question come in? Okay, thank you very much. And also, I promised that somebody was going to say something about litigation financing. Can you get financing for this sort of litigation?
You haven't been able to historically, but there is Reporters' Shield, isn't there now?
Yes.
Yes, it's just been set up.
Would you like to say a word or two about that for the...
I think you probably know.
Well, we
better
have
than
a
I do.
panel tomorrow. I can see Peter Norlander here in the audience. He's going to be talking about it tomorrow.
Okay.
And it's a worldwide initiative in the sense that it's not just going to apply in the US, although it has been underpinned by US funding. But one thing that we have as an additional recommendation as the coalition is the expansion of legal aid to defamation, which, I mean, that would be something relatively straightforward and would be a huge help to a lot of people. So it'd be great to see that taken forward.
Great. We've had a question about a specific case, and there's a book. Are you familiar with a book called Financing Evil? If not, I'm not going to be able to ask you the question about it.
I don't.
No, we'll wander away again and think about it. But it was a case of Mahfouz versus Ehrenfeld. And the question was, would it be decided differently today in light of the rules on SLAPP? But I think that's a bit of homework, isn't it? Let's take that away and have a look at that. Well, ladies and gentlemen, I'm not going to press you. I think we're within a few minutes of time. So why don't we all have a break? And you can enjoy the next session, which starts at?
At 12.
At 12. So you've got a few minutes to, you know, go.